Hello, everyone. My name is Maya Simek, and I am very excited that you could be here today for our CLE about the Supreme Court's influence on LGBTQ equality. I am an attorney and a licensed independent social worker who has the privilege of working in two wonderful organizations. I work as the legal director for Equality Ohio, and I also am lucky enough to work as the director of the Human Trafficking Law Clinic at Case Western Reserve School of Law's Milton A. Kramer Law Clinic. And I use she and her pronouns. Today I wanted to talk a little bit about what we do at Equality Ohio and the clinic, so you can kind of get a sense of the work that we do. Some definitions, so we can have a foundation of some of the terms that we will be discussing in the cases. A history of the Supreme Court of the United States cases, both from 1958 through 2000, and then again after 2000 to present, and where we are today in terms of our patchwork for protections. At the Human Trafficking Law Clinic at Case Western Reserve, what we do is we provide free direct legal representation to individuals who are survivors of sex and labor trafficking, as well as individuals who are at high risk for sex and labor trafficking. And some of those targeted populations who are vulnerable to trafficking include members of the LGBTQ community, refugees, and individuals with mental health and/or substance abuse disorders. Using a trauma-informed approach, we allow third-year law students, as well as master's level social work students from the Mandel School of Applied Social Sciences, to work together to create a holistic safety net addressing the needs of the individuals that we work with. With regards to my other hat at Equality Ohio is a statewide LGBTQ organization that seeks to identify and transform systems so that LGBTQ plus Ohioans can have full access to lived and legal equality. And this is done through state house and agency advocacy, municipal policy work, public education programming, as well as direct legal representation. Equality Ohio strives to identify those areas of the law which have a disparate impact on members of the LGBTQ community so that their lived equality can begin to match the legal equality that they experience. The direct representation that Equality Ohio actually provides was just launched in 2019, and it is in Cleveland, Columbus, and Cincinnati, providing free civil legal representation to members of the LGBTQ community who are 300% of the federal poverty level and below. Both the Human Trafficking Law Clinic and Equality Ohio focus on what we call stabilization law, and both clinics do have a partnership with one another, working on these areas of stabilization law or areas in which an individual has come across a barrier which is making it difficult, if not impossible, to stabilize. And through the removal of that barrier, we hope that we will help to work with the individual to move forward and work towards thriving. So let's get started in terms of some of what we came here to talk about today. And the first foundational step we wanted to discuss is LGBTQ terminology. With regards to LGBTQ terminology, one of the foundation terms that we think is important is SOGI. And SOGI stands for sexual orientation, gender identity, and expression. And SOGI is a term that you will be hearing with more frequency in the upcoming years. And in Cuyahoga County, where I am currently recording from, it is a term that we are hearing across all kinds of different systems, ranging from juvenile justice to foster care. SOGI data is being explored, examined, and collected because it is known that someone's sexual orientation and gender identity is important in helping them to move forward, as well as providing access into some of the heightened vulnerabilities that individuals from different sexual orientations or gender identities might be at risk for. So when we're talking about sexual orientation is the quality in which someone has attraction, typically referred to romantic or sexual attraction to other individuals. Gender identity is when someone closes their eyes and thinks about themselves. It's how they see themselves to be male, female, both, or neither in terms of their identity. And it's important to note here that one's gender identity, again, that felt sense of self, can be the same as was assigned at birth, which is known as cisgender, or different from the sex that was assigned at birth, which is termed transgender. Gender expression, then, is how someone chooses to express their gender and their gender identity externally. And typically this is done through elements such as behavior or clothing, hair, nails, makeup. And it's important to note here that it may or may not conform with society's expectation of what the belief is that that gender should look, feel, and display as. One tool that we have traditionally used historically to explain gender and sexual orientation, gender identity, and expression is the gender unicorn. And this is a great teaching mechanism as well as allowing folks to identify that you are a safe person to talk to about these terms and topics. And if you see the circle that is here, that is if you envision it as a slidable scale, it would allow people to move their scale down as far or as little as they would like in order to show how they identify. So in terms of gender identity, for example, you can see that someone can identify as female, male, or other genders. In terms of expression or presentation, we see feminine, masculine, or other, and so on down the line. It's just a helpful tool with acknowledging that there are different ways in which each of these interplay. And it's also important to understand that each of them are separate. So just because someone identifies as female does not mean that they're going to express in the same way as someone else who identifies as female, nor does it mean that you have a sense of their sexual attraction or their emotional attraction, even though you know their gender identity or their expression. So using that, I love to jump to this picture. This is Billy Porter, who is a fabulous performer and actor and wore this outfit on the red carpet. And when he was wearing this outfit, you can see a standard tuxedo top. And then in the bottom, this wonderful, what looks and goes into a velvet skirt. And there is a cross presentation here between traditional feminine attire and traditional masculine attire. And so the way that this is being presented in terms of gender expression is kind of a mix. And it also causes some people to stop and pause and maybe tell themselves stories about who they think Billy Porter is, what they think his sexual orientation is or gender identity is. And it's something that I just like to point out because we never can tell. And we always have to question ourselves what stories we're telling ourselves about other people based on how they're moving through the world and how that may not necessarily be congruent with how they identify. So it's a way to just keep challenging yourself to look beyond the ways in which perhaps you were socialized without making assumptions of people. Coincidingly, two other terms that go along with our terminology would be sex stereotyping, right? And so sex stereotyping is when you do have an assumption about someone's appearance or behavior based on who they are and how they present, which includes and is not limited to what kind of work they're able to do and what other general expectations you carry about them based on your understanding of their sex. Further, the last term that we wanted to just cover is transitioning, which is the process by which some transgender people begin to show how they identify with their gender and choose to express it. Sometimes, but not always, this can be done with medication or surgeries. This can be done with clothing or presentation. There are a multitude of ways in which someone may transition to try to have their expression more intimately aligned with how they're feeling on the inside. And it's important to note that this is not done, there is no prescribed way of doing it. You do not have to have a surgery, you do not have to have medication. You can transition, people are able to transition in whatever way is appropriate for them. Okay, so let's jump in. We are going to talk about the SCOTUS LGBTQ case history. So looking at the SCOTUS history with cases that deal with specifically the LGBTQ community, we tend to find that the case types have fallen into predominantly 4 buckets. So we have seen sodomy laws, marriage, freedom of speech or association, and non-discrimination protections. And the most recent 3 cases that have either been decided in 2020 or are currently in the process of being before the Supreme Court, as we see in Fulton, are dealing with the bucket of non-discrimination protections. So looking back over the period between the 1950s through the 1990s, we see about a 42-year period of time wherein there's about 6 cases that we have focused on that deal specifically with the LGBTQ community, or at least with the LGBTQ community adjacent. So starting here, the first case that is prevalent and that should be noted is One Inc., which was in 1958. You can see some of the photos at the bottom of the page, and what these are actually are magazine covers, as this deals with an issue of whether or not a magazine that was dealing with homosexuality was allowed to be printed and mailed. So essentially, the One magazine had been established to be a pro-gay magazine dealing with quote-unquote the homosexual lifestyle. And as early as 1954, the United States Post Office, as well as the FBI, had found that the magazine was deemed to be obscene, lewd, and filthy, and therefore should not be mailed. And the magazine obtained representation, who brought a suit in the U.S. District Court to get an injunction against the post office, but ultimately this was rejected, and the district courts had stated that the ask was to accord special privileges to homosexuality as a class, and they did not agree. And this decision was appealed to the U.S. Supreme Court, who both accepted the case and then, without hearing oral argument, actually reversed the Ninth Circuit, stating that, just because the magazine spoke about homosexuality does not mean that on its face it had violated any obscenity laws. And so in this landmark case, which is the first case for SCOTUS to ever talk about anything LGBTQ related, it is established that just by talking about the community at large, it is not found to be obscene. So then we go to 1972, over a decade later, and we see Baker versus Nelson. And so in these pictures, you're looking at James Michael McConnell and Richard John Baker, who had gone and applied for a marriage license in Minneapolis. And they were denied on the sole grounds that the two of them were of the same sex. And so they had gone and then they filed suit in the district court to try to force Gerald Nelson, who was the clerk of the district court, to issue a marriage license. And what the Minnesota Supreme Court decided was that construing a marriage statute to limit licenses to persons of the opposite sex does not offend the United States Constitution. So it is constitutional. And this case was appealed by Baker to the United States Supreme Court, but they dismissed the appeal for a want of a substantial federal question. And so by refusing to take this case up, it actually established that the dismissal constituted a decision on the merits and established Baker through the extent of its presidential effect that opposite sex marriages were found to be constitutional and same-sex marriages were not, which how this case was interpreted therefore. So moving forward, the next case of note that I wanted to discuss briefly was Bowers versus Hardwick, which is in 1986. And so another handful of years later, about 6 years later, we have Bowers, and what Bowers is telling us, facts of this case are a police officer ends up going into a private residence on an invalid warrant and finds two men engaged in sexual activity inside of the home. And initially he arrests them under a Georgia statute, which was for sodomy laws, and that carried a sentence of 1 to 20 years of imprisonment. But the district attorney decided not to prosecute, considering that the reason why the police officer had been in the house in the first place was based upon a warrant that had expired, as well as his own personal belief that sodomy laws shouldn't be used to prosecute consensual activity, sexual activity. However, Hardwick, one of the gentlemen that had been arrested and the charges had been dropped, then sued the Attorney General of Georgia, Michael Bowers, because he stated that as a member of the gay community who was non-celibate, he was eventually able to be prosecuted under this law, these sodomy laws, for his activities. And so they took up the case, and ultimately what was found was that the United States Supreme Court ruled in a 5-4 ruling that the sodomy law was able to be upheld because the Constitution does not confer a right for gay individuals to engage in even consensual intimate acts, and even in the privacy of their own home. Concurring opinion by Warren Berger cited that there had been prohibitions against homosexual sex as an infamous crime against nature, worse than rape, and a crime not fit to be named, and further held that to hold the act of homosexual sodomy is somehow protected as a fundamental right would be to cast aside a millennia of moral teaching. And so, walking away from this case, we have determined that sodomy laws are okay, and the criminalization of sodomy is acceptable, and even for consensual acts that occur in private. So of note, the dissents, interestingly enough, we had Blackman, Brennan, Marshall, and Stevens stated that there was an implication of a right to privacy in this case, as the acts had occurred both in home and of personal association. And the other dissent, which was Stevens joined by Brennan and Marshall, stated that the statute in question could not be constitutionally applied to all people, as there was an exclusion of the acts between married couples and between unmarried heterosexual couples. And so the dissents were important as just to note, because they are definitely something that you see pop up later throughout. So 3 years later, if we're thinking back to some of the terminology that we spoke to at the beginning of the presentation, you'll see this implicated in Price Waterhouse versus Hopkins. And so what happens in 1989 is that Ann Hopkins sued her former employer, Price Waterhouse, and she argued that the firm had denied her a partnership because she didn't fit the partner's idea of what a female employee should look like and act like. And stated that she had been told by the supervisor of her department that in order to increase her chances of promotion, she needed to, quote, walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. And even though she was well qualified for the partnership and had frequently outperformed her male coworkers, it had been made known that male employees said they would not be comfortable having her as their partner because she did not act in the way that they believed that a woman should. And so when this case goes to the Supreme Court, what happens is that the court established that this constitutes sex discrimination under Title VII of the Civil Rights Act of 1964, which establishes that not promoting someone because of their sex, but also refusing to promote someone because they do not conform to stereotypes of what their sex should be based on societal norms, right? Is against Title VII. And if the plaintiff can establish discrimination occurred, the burden is going to shift to the employer to demonstrate that the results would have been the same. So we see now that there's an establishment of sex stereotyping and how that is going to begin to shape what and how the expectations of gender identity and gender expression can tie into discrimination. In 1995, another 6 years later, we come across Hurley versus the Irish American Gay, Lesbian, and Bisexual Group of Boston. And so what happens there is that there is a fantastic parade that is happening in Boston ever since 1901 that celebrates both St. Patrick's Day and Evacuation Day, which had marked the departure of British troops from the city in 1776 on or about March 17th. And so it's a very big deal. And the Irish American Gay, Lesbian, and Bisexual group requested that it be allowed to march in the parade alongside the typical groups that were participating. And they argued that it was not their intention to convey a gay lesbian message. They just said that as Irish members of the community who were also happened to be LGBTQ, they were proud of both who they were in terms of their sexual orientation, gender identity, and their Irish ancestry, and they wanted the opportunity to march. However, after several years, there's actually several years of contention between the groups, between the parade organizers and between this group. It goes to the Supreme Court, and the Supreme Court holds an anonymous decision, unanimous decision, excuse me, that the First Amendment protects the parade organizers from being forced to include unwanted messages in the parade, and that the parade was a form of expression, and the fact that the banner that the LGBT group wanted to hold would have forced the parade organizers to have a message that they did not wish to impart. And the court ruled that private organizations, even if they were planning on and had permits for a public demonstration such as this parade, were permitted to exclude groups if those groups presented messages contrary to what the organizing group wanted to convey. And that expressing a message that the organizers do not wish to convey violates the First Amendment. Violates the organizers' free speech. And what's more is that Boston had a non-discrimination ordinance at that time. And even though there was a non-discrimination law, the Supreme Court still established that the First Amendment free speech rights of the private groups to define the parameters of their expressive conduct during a parade trumped the provisions of the state non-discrimination law. So next we see, so you're starting to see the pattern here. For the first 42 years of this history, we have a lot of adverse to the LGBT community cases that are coming up and kind of etching out what it looks like to be able to assert oneself as a member of the community, and where you're protected and where you're not, and what that protection looks like. So we see now in 1996, our next case is Romer. And in Romer, we have a little bit of a shift that starts to happen in 1996. And so what happens in Romer is Colorado voters had approved an initiative to an amendment to the Colorado State Constitution, which would have prevented any city, town, or county in the state from taking any legislative, executive, or judicial action to recognize homosexuals or bisexuals as a protected class. And in the late 80s, Colorado Springs had seen an influx of some evangelical Christian groups that had opposed some of the legal and political gains that had been made by members of the LGBTQ community. And so they had worked to get this constitution placed on the ballot. And this constitution would prohibit the passage of any legislation moving forward, which would protect members of the LGBTQ community. And what happens is that this case goes before the Supreme Court, and essentially Justice Harlan states that the Constitution, quote, neither knows nor tolerates classes among citizens, and then states that the Equal Protection Clause enforces this principle and requires to hold invalid their Amendment 2 due to the fact that the amendment would have imposed a special disability against the LGBTQ community by forbidding them to seek safeguards. And Justice Kennedy wrote that it did not even meet the lower requirement of having rational relationship to a legitimate government purpose. It was seen as both too narrow and too broad, identifying persons by a single trait and then denying them protection across the board, resulting in disqualification of a class of persons from the right to seek specific protection from the law, which is unprecedented in our jurisprudence. So it becomes very important for us as we were looking at the history of the LGBTQ case laws of SCOTUS, because we are seeing that the court is having a shift against having these it's moving away from not protecting the community and allowing recognition that you cannot discriminate against the community just because you want to discriminate, and have laws deeming that it would be acceptable to do so. So moving into the 2000s, we have another 7 cases that actually we're going to be looking at. And the first one that we're looking at starts with the Boy Scouts of America versus Dale, which is in 2000. And we see here on this picture actually is Dale, who had been a student of Rutgers University, as well as a co-president of the LGBT Student Alliance. And he had attended a seminar and given a quote in a newspaper in which he was quoted as saying not only was he was gay, but he commented on issues of youth that were members of the LGBTQ community. And Dale was also a scout leader at that time. He was a scoutmaster, assistant scoutmaster of a New Jersey troop, and the Boy Scouts of America had read this interview and then expelled Dale from his position, indicated that the Boy Scouts did not believe that that Dale was representative of the moral code that they wished to convey. And Dale went and sued under the New Jersey law prohibiting discrimination based on sexual orientation for public accommodations. However, in a 5-4 decision, the Supreme Court decided for the Boy Scouts of America, indicating that the Boy Scouts asserted that teaching that homosexual conduct is not morally straight, and that it does not want to promote homosexual conduct as a legitimate form of behavior was within their rights. And moreover, the court deemed it sufficient that the Boy Scouts had taken an official position with respect to same-sex relationships, and that the presence of an openly gay activist in an assistant scout master position would, excuse me, so the presence of an openly gay activist in the scoutmaster's uniform would send a distinctly different message from the presence of a heterosexual assistant scoutmaster, and that the Boy Scouts had a First Amendment right to choose to send one message and not the other. So this landmark decision stated that the Boy Scouts of America had a constitutional right to freedom of association, and that the constitutional right of the Boy Scouts to freedom of association allowed them to exclude a homosexual person from membership, even in spite of the state law requiring equal treatment in public accommodations. So in this 5-4 decision, the Supreme Court ruled that opposition to homosexuality was part of the Boy Scouts' expressive message, and that allowing homosexuals as adult leaders would interfere with that message. And so they were allowed to exclude Dale and anyone else who did not coincide with their teachings. So 3 years later then, we are seeing Lawrence versus Texas in 2003. And what we see in 2003 is that the police, in Houston, Texas, the police enter a house after a reported weapons disturbance. And when they enter the house, they see 2 men engaging in private consensual sexual activity. And the 2 men were Lawrence and Garner, which we see here on this slide. And they were arrested and convicted of deviant sexual intercourse in violation of a Texas statute forbidding people of the same sex to engage in certain intimate conduct. And so this goes up to the court, and it questions whether or not two private same-sex couples who are consensually adults engaging in activities in the privacy of their own home should be a protected act. And the Supreme Court held that in a 6-3 opinion delivered by Justice Kennedy, that the Texas statute, which had made it a crime for two people of the same sex to engage in certain intimate sexual conduct, violated the Due Process Clause, and that the right to liberty under the Due Process Clause had given individuals the right to fully engage in conduct without intervention from the government, and that the Texas statute furthers no legitimate state interest which can justify intrusion into the personal and private life of the individual. So the focus here had been that some of the key factors of the decision were that the sexual acts happened inside of a private residence, and where the state and the law enforcement had no right to dictate individual behavior in these matters because it was between two adults within a house, and ergo should not be something that was able to be punished. So this is an important case because it does strike down the precedents that we had seen had been established in Bowers versus Hardwick, and had found that these intimate relationships between two same-sex people had become a little bit more widely accepted in society and could not be criminalized in the same fashion. And so protection of this conduct became a fundamental right under due process, and it became an important turning point, again, notably for the LGBTQ community. So 10 years later, notable case that I'd like to discuss is the United States versus Windsor, which is in 2013. And in 2013, Edith Windsor and Thea Spire had been a same-sex couple residing in New York, and they had had their marriage recognized by the state of New York in 2008. And when Spire had died in 2009 and left her entire estate to Windsor, Windsor had sought to claim the federal estate tax exemption for surviving spouses, but was barred from doing so by Section 3 of DOMA. And so, seeking a refund, Windsor had sued the federal government in the District Court of New York, but the Department of Justice declined to defend the constitutionality of the section and of Section 3 of DOMA, and therefore the bipartisan legal advisory group called BLAG had intervened to defend the law. And so the district judge had ruled that Section 3 of DOMA was unconstitutional, and her ruling was actually affirmed by the U.S. Court of Appeals for the Second Circuit. However, the court did go up to the Supreme Court, and what happened in the Supreme Court was that the majority holding, which was Kennedy and Ginsburg, Breyer, Sotomayor, and Kagan, held that a definition of marriage as being a legal union between one man and one woman under DOMA deprives same-sex couples who are legally married under state laws of their Fifth Amendment rights to equal protection. And so this was a game changer, and this actually happened to allow DOMA, the Section 3 of DOMA, which said that, denied federal recognition of same-sex marriages, was no longer valid in terms of both determining legal protections and federal benefits. So this is a great stepping stone towards the recognition of same-sex unions, and achieving more of an equal status under the law. So 2 years after this, we see Obergefell versus Hodges in 2015. And this is a conglomeration of several states. And what happens here is that the plaintiffs had argued that a variety of state statutes banning or refusing to recognize legal same-sex marriages from other jurisdictions violated the Equal Protection Clause and the Due Process Clause of the 14th Amendment. And several same-sex couples had filed suits in federal district courts in their home states, asking for their right to marry or to give full faith and credit to their out-of-state marriages. So the states were consolidated, and there were 4 of them. 4 cases were consolidated by the Supreme Court under the title Obergefell and Hodges. And when the Supreme Court granted certiorari, they ultimately found that in a 5-4 decision that same-sex marriage is protected under the due process and equal protection clauses of the 14th Amendment, and that same-sex marriage bans had been struck down as unconstitutional, and that same-sex marriages performed out of state must in fact be recognized in other states. One of the notable quotes for this case is that no union is more profound than marriage, for it embodies the highest ideal of love, fidelity, devotion, sacrifice, and family. In forming a marital union, 2 people become something greater than they were. And with that, the right to marry became a fundamental right that was inherent in the liberty of the person and under the due process and equal protection clauses of the 14th Amendment, and couples of any same-sex partnership were not to be deprived of this right and liberty moving forward. So after this, now we are looking at Masterpiece, which comes 3 years later. So we have a lot of marriages happening, and of course people start wanting to do marriage things, right? And so Masterpiece is where a couple comes. We have Charlie Craig and Dev Mullins, who go to Masterpiece Cake Shop, and they are getting married, and they want their owner, the owner of the cake shop, to create and design a cake for their wedding. And the owner, Jack Phillips, says that doing so, creating wedding cakes for same-sex couples, is not something he can do based upon his religious beliefs. And he believes that decorating cakes is an art form in which he uses, because it's a talent he had received from God, and that it would displease God to create cakes for same-sex marriages. So Craig and Mullins filed charges of discrimination with the Colorado Civil Rights Division, and they allege discrimination based on sexual orientation under the Colorado Anti-Discrimination Act. And it is taken up, and the finding is that the Colorado Civil Rights Commission finds that it's in fact that that Mr. Phillips had in fact discriminated against the couple in refusing to make the cake. So this case was appealed to the Colorado Court of Appeals, and they had affirmed the commission's finding, which was then appealed to the Supreme Court. And what happens in the Supreme Court is that the court actually decides in a 7-2 decision to reverse, holding that the Colorado Civil Rights Commission's conduct in evaluating the cake shop owner's reasons for declining to make the wedding cake had violated the free exercise clause. And they had stated that religious and philosophical objection to same-sex marriage are protected views and can also be protected forms of expression. But the commissioners the majority acknowledged that they had not provided neutral treatment in analyzing the case, and the members of the commission showed clear and impermissible hostility towards his religious beliefs. And since they don't feel that the conduct of the commission was done with impartiality, the case was actually sent back down in order to be decided on the merits. And so they believed, the Supreme Court believed that the commission's actions violated the state's duty under the First Amendment not to use hostility towards religion or a religious viewpoint as a basis for laws or regulation. And so this narrow holding actually left unresolved questions about whether or not a business may be mandated to provide services for members of the LGBTQ community if it violates their free exercise of religion, of a sincerely held religious belief. And so that was not actually decided with Masterpiece as it was sent back down. So to date, now we're starting to turn and look towards some of the current Supreme Court cases and the patchwork of protections that they have established. So looking back, we have seen sodomy laws, right? So sodomy laws being where they were upheld and then overturned, marriage being sequentially, given full recognition under the law. Freedom of speech or association actually still having some interpretations of the fact that you can, in fact, deprive someone or not force someone under First Amendment or freedom of association to impart a message that they don't agree with, even if there is a non-discrimination ordinance protecting individuals of a certain sexual orientation. And then we see non-discrimination protections. And so we had just seen Masterpiece, which was not decided. And then we had Romer, which again says that you cannot institute discrimination against a group, not allowing them to be able to be protected in Romer and making them a second-class citizen. So now in 2020, we actually have 3 different cases that continue to define and roll out what a non-discrimination protection looks like for members of the LGBTQ community. Okay, and so what we see in Bostock in 2020 is that we have several circuits that are all looking at different elements of sexual orientation or gender identity discrimination and trying to grapple with whether or not these different categories on the basis of sexual orientation or gender identity are in fact categories which would fall under the because of sex argument that we saw in Price Waterhouse versus Hopkins, right? So is it sex discrimination if it's discrimination against a person because of their sexual orientation or of their gender identity? And so we see that the Second Circuit is finding that sexual orientation discrimination does constitute a form of discrimination because of sex under Title VII. The 11th Circuit is saying that sexual orientation does not apply based on sexual orientation. And then 6th Circuit is finding that gender identity, found that firing someone based on gender identity was sex under Title VII for sex discrimination. So in these cases, Altitude Express was a skydiving instructor whose employer had terminated him when he told a female client that he was gay. And he had been terminated. There were some allegations there of the instructor inappropriately touching the client, and he had effectively been terminated, and he felt he was terminated on the basis of his sexual orientation. Then there was Bostock versus Clayton County, where Bostock had been an employee for 10 years with Clayton County with the juvenile court. He had joined a gay softball league, and that it reported that people with significant influence on Clayton County's decision-making had ridiculed and disparaged his participation in the league, and he was terminated 3 months after these same individuals had found out. And an internal audit, was conducted on his program. And then in the Sixth Circuit, RGGR Harris Funeral Homes had found that Amy Stevens, a transgender woman who had been a funeral director for almost 6 years, had come out to her employer as wanting to transition and requested to wear the corresponding attire so that she can express her gender identity in a way that matched her her presentation, her want to present as a female, which aligned with her identity, and her supervisor fired her, stating that the request violated his religious beliefs. And so the Supreme Court consolidated these cases and ultimately grappled with the issue as to whether Title VII prohibits discrimination against employees based on their gender identity or sexual orientation. And Title VII says, just as a refresher, that it shall be unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. And so they're trying to determine, on the basis of sex in the context of Title VII, what it means. And so SCOTUS is considering, again, does sex-based discrimination under Title VII include discrimination based on sexual orientation and gender identity? And the Supreme Court held that the answer to this was yes. Title VII absolutely prohibits an employer from firing an individual merely because they are gay or transgender. And Justice Gorsuch, for a 6-3 majority, indicated that for an employer to discriminate against employees for being homosexual or transgender, the employer must intentionally discriminate against individual men and women, in part because of sex. That has always been prohibited by Title VII's plain terms. And he goes on to say that to refuse enforcement just because of that, because the parties before us happen to be unpopular at the time of the law's passage, would not only require us to abandon our role as interpreters of the statutes, it would tilt the scales of justice in favor of the strong or popular and neglect the promise that all persons are entitled to the benefit of the law's terms. So this is a huge win for states such as Ohio, where I am located. There is the interpretations that are taken locally from how Title VII is interpreted. And this can also go on to impact other different provisions in other different areas of law, such as Title IX. So Title IX of the Educational Amendment Act of 1972 is a federal law that states and has direct implication for how individuals are able to be excluded from or participate in educational programs or activities such as sports for those programs that are receiving federal financial assistance. And we can definitely see this impact go into other areas of law as well. Some things that are notable is that while this was substantially important for both the case law and the recognition, this does only apply to individual employers with more than 15 employees. And so this is not for smaller employees. This is only if an employer has 15 or more employees. And if not, this application, this ruling is not applicable. It also does not address religious exemptions, and the decision does not cover public accommodations, or housing discrimination, which means that we are still seeing this patchwork of protections, which we're going to talk a little bit more about a little bit later, and necessitates that statewide discrimination protections are still needed, as there is no global federal law that is protecting in these areas, that we are seeing this carve out for 15 or more employees under Title VII, but we still have identified there are many other areas that lack such protections. The next case that we saw in 2020 is Our Lady of Guadalupe. And this was, again, another consolidated case. And the consolidated case had seen that two teachers had found themselves not being offered contract renewals. Both of them had filed discrimination cases against their schools, against their former employers. One individual had experienced health concerns, and one had experienced what she felt was age discrimination. And the issue, as presented before the court, was whether the religious clauses prevent civil courts from adjudicating employment discrimination claims brought by an employee against a religious employer, where the employee carried out important religious functions. And the Supreme Court goes on to hold is that the ministerial exception under the religious clauses of the First Amendment prevents employment discrimination claims of any kind for the Catholic school teachers in these cases. So the holding finds that a person can be serving an important religious function, even if not holding a religious title or the training of a religious leader. The fact that they were still employed by a religious employer satisfied the ministerial exception in employment discrimination and renders them unable to bring discrimination cases. So it expanded the ministerial exception pretty much, making it very difficult for teachers to bring any type of discrimination case against the school, because of the fact that employment decisions are held based on the application and the belief of the religious, what is best for the religious instruction in that time, and that is more important, overriding access to discrimination causes of action. So what is next? What is next is that we are seeing that Fulton versus the city of Philadelphia, Pennsylvania is currently, just this month, November 2020, having oral arguments before the Supreme Court. And what is happening here is that the city of Philadelphia had two agencies that were providing foster care services to children in public child welfare systems, and had found that both of them would not issue license to same-sex couples to be foster parents based on the agency's religious beliefs. The city had said that both agencies' contracts had prohibited such discrimination and therefore had stopped referring children to them. One of the agencies agreed to comply and start issuing licenses to same-sex couples, and the other, which was Catholic Social Services, had claimed the right to free exercise of religion and stated that this entitles a taxpayer-funded contract to perform a government service, even though it's unwilling to comply with the requirement to accept all qualified families. So the issue before the court right now is whether religiously based social welfare organizations that receive taxpayer dollars through local government contracts can be exempt from the government's non-discrimination laws. And what that means in practicality is that there's a possibility that a decision in Fulton could come to mean that nearly any religious entity or even a private company asserting its religious beliefs would have permission to refuse to serve or work with anyone simply because of who they are. And so this is a very weighty decision that can have a lot of far-reaching implications. And the next question that the court will be deciding is whether the government violates the First Amendment by conditioning a religious agency's ability to participate in a system such as the foster care system on taking actions and making statements that are directly contradictory to the agency's religious beliefs. So we should be seeing this decision come within the next 6 months. And this is just definitely going to be something that is absolutely going to impact the next stage of rights that as they are rolling out on the chain of this timeline. So what we have now is a patchwork of protections. And so this patchwork of protections that I had mentioned in the past basically asserts that because there are no federal non-discrimination protections across the board, every state ends up having this blanket of protections in areas such as employment, housing, and public accommodations. And public accommodations are any place that you go that is in the public, such as a restaurant or a store or a movie theater, for example. And as you go state by state, if there are no federal provisions, then you look next to state and then to local, meaning that you can travel in certain places and you can actually find yourself covered in one municipality, one county, and then driving another 10 minutes falling out of coverage of protection. So when we're looking at Ohio, for example, this is a map of non-discrimination laws, and you see that the map that is in blue are states with non-discrimination laws based on sexual orientation and gender identity. Green, Wisconsin, has a non-discrimination law based on sexual orientation only. And then you see gray, which is all of the states that do not have any statewide non-discrimination protections. And you can see, so in Ohio, where we are from, there are no protections across the state. It is county by county or city by city dependent. And what that means essentially is that you could invoke your federal right, which has been guaranteed, as we saw under Obergefell, to get married. And then you can get married, and then you can go to try to rent an apartment in Ohio, and based on which city you are in, you may be legally denied access to housing. And then if you go to work and you put your wedding picture on your desk, you may in fact be still able to be legally let go or fired based on the fact that of whether there are protections in that city. And so there is definitely some disconnect between some of the rights that have been afforded with some of these cases and the way that they actually translate. So again, the legal versus lived equality that we are seeing play out based on kind of the discordant application of some of the rights and remedies as a result of these cases. So right now, stay tuned. Be looking for what is going to be happening with Fulton. And yeah, if you have any questions or if you have any follow-up, please feel free to contact me. My email at Case Western is mms48@case.edu. And my email at Equality Ohio is Maya, M-A-Y-A, at equalityohio.org. But I thank you sincerely for your time. I hope you got something out of the CLE, and I hope you keep on learning. Have a great rest of your day. Take care.